So we have moved item 10C to the second meeting in June. So now we're on to committee reports. Before I give you a committee report from the Planning Policy Committee, does anybody else have something that they would like to say?
Should we take care of the projector first before?
Oh, yes. Can we?
You know, I don't want to see the bright light just yet. Forgot about that.
Thank you, Councilor Hart. That's lovely. Thank you. So,
Never going to turn on again.
so we're at committee reports, and I don't believe any other counselor had a committee report that they wanted to give. I do have something from the policy committee. The policy committee will be meeting tomorrow. We met last Thursday, and we need to get some guidance from council. As the council has directed us in the past, we've been investigating the possibility of establishing a social media policy. We contacted NHMA. They had some cautionary advice, but no real example of a social media policy. Then the next step we took was to work with legal counsel, Christine Fillmore, to get her input. And basically what she has advised us is that we could go one of two ways, and that is to have a standalone social media policy or update the code of conduct to include some guidance with regard to social media. And I gave you the whole email correspondence chain earlier this morning about this if you want to have it for your reference. This is correspondence that the members of the policy committee have had an opportunity to look at. But the reason why the policy committee wanted to bring this to the council is if we want to move forward with updating the code of conduct to include guidance with regard to social media, it's going to require more of the legal counsel's time, which means more legal expenses. So I just wanted to get feedback from the council, and so I could provide guidance to the policy committee when we meet tomorrow. Councilor Kolaski.
I'm not interested in spending any more taxpayer dollars to go down this road. After I was at the policy meeting, and when concern was raised as far as from the sheriff, as far as a state law and not being able to have any say as far as employees saying what they want and having any repercussions, I just go back to when you are sworn in as a counselor, there are certain things that you abide by, are supposed to. I remember those. There was one that I've remembered always, and if it's something that is going to be before us, we're not discussing that in any form. You shouldn't be standing at Market Basket talking about your decision and what's going to be rendered without that conversation taking place here. I think part of what we've seen is talking about things that are potentially coming before council, and that has already been that should already be addressed when you're sworn in. I don't think there's any legal standing to or any way to enforce any policy that has to do with someone using their own personal Facebook account. I will tell you, I'm probably one of the most vocal on social media. I answer questions all the time on What's Up Claremont. I don't want to walk a fine line where, ooh, I can't answer you anymore, or you disagree with my opinion on something. that's fine. I've argued with lots of people in the community over not something that's coming before us, but I will always defend my decision online. There's been cases where, and this council's alluded to it without elaborating, but language or conversation towards a seated state rep at the time. Well, I will let you know that that's my conversation, and that was me defending myself and my family from attacks. And any policy is not going to change me doing that. I will always defend my decisions. I know this policy isn't being crafted for my benefit, but I will just tell you that of all the years that I've sat here, I pride myself on being able to answer concerns in the community, and I really think we're going down a road that is not enforceable. To even have that language in there and have the ability to have that challenged, I think is talking about expending tax dollars to travel that road and then have to defend that decision.
Okay. Other comments? Because I know you're on the policy committee, so for anybody who is not on the policy committee that would want to speak to what Councilor Kolaski said or to this topic in general. Assistant Mayor Dameron.
Yeah, I think Councilor Kolaski raises a particularly valid point. Hearing the introduction to this topic, I would have initially said, certainly make it part of our code of conduct. However, I was immediately swayed that was not such a good idea when it was mentioned that would be the cause of more legal fees to be expended for that effort. I fully understand why we're at this point, but I do agree with Councilor Kolaski that this may be a road we don't need to travel.
Okay. Councilors.
Just make sure everybody else is. I'm last.
Okay, Councilor Ahern.
I'll say I agree. It's not the road to travel.
Okay. Councilor Stone.
My turn?
Yes.
Okay. One of the questions that came up at the policy meeting was 98E RSA, which is the freedom of expression for state employees. Now, so today I called the Municipal Association, spoke to Attorney Gray, who's one of the new staff attorneys, and I asked him point blank, I said, does this RSA 98E come under anything to do with elected officials? And he said, absolutely not. Could you imagine having a policy that would stifle a politician's ability to speak on a matter and have it set to policy on either the federal, state, or local level? When establishing policies, they need to be in conformance with the law. And I know there's some councilors that don't think they need to follow the law on certain things, and that's come up before, and they've made that publicly known. The freedom of speech is one of the most protected ones we have. One of the things we have to remember is you have the United States Constitution and the New Hampshire Constitutional, which also protects that. Okay? If you create any legal policy, you're taking liability onto the community that is going to have to be defended. Trying to merge, and I've said this before at the policy meeting, trying to merge a code of conduct with a particular law is basically unenforceable and not reality. You can't draw the inference in the two. We had a legal opinion that was seeked out, and we provided it on January 10th of 2019. Does everybody recall that email from the attorney that I believe was forwarded from Doré? And it basically says of what the abilities the council has and what they don't have. And you cannot stifle someone's freedom of speech, plain and simple. You can go doctor shopping with attorneys until you try to get a legal opinion close to what you want, but at the end of the day, you're just giving them more money. Every time you pick up the phone or send an email, it's costing the taxpayers money for a fishing trip they don't want to pay for. And I think that's where we're at. You cannot enforce stifling any political speech, period. Whether you agree with it or not, we're all going to disagree with things. That's the purpose of having a council made up of 9 individuals, is to have differences of opinions. We don't want everybody to have the same opinion. What you may think is inappropriate, I may think is appropriate, and vice versa. We all have our different positions that we take on certain items. But not having the ability to speak is a significant issue in stifling it for any political base. Go ahead.
Councilor Keir.
So I certainly wouldn't disagree with you. I think that, at least from my point of view, that's not the purpose of what this should be. I do think it makes sense to be part of the code of conduct because it's not a legal document. It's not binding. It's giving direction to people who are working in an official capacity for the city. And when I read through Christine, what is her name? Fillmore, excuse me, sorry. Her email, what struck me was she was just talking about the major topics I've identified thus far that should be addressed include keeping official business on official social media accounts, which I agree with, keeping campaign and personal matters on personal accounts, makes sense, avoidance of using private social media accounts in a way that could violate the open meeting and government records provisions of RSA 91-A, makes sense, potential for disqualification for bias based on statements made on personal accounts. That is important for some of our semi-judicial committees, which we talked about in that meeting, that has arose before and quite recently, where that could sway how you are, what's the word I'm looking for? Your outcome of how you vote in those meetings. That is important. I do think that should be in there. Avoiding First Amendment issues that may arise from blocking someone from a personal account to closely linked government business. Confidentiality issues, of course, and guidance on decorum and respectful behavior. Now, I think the majority of those are very understandable, basic topics that we should have in there. This is just a guidance to be put into our code of conduct that helps to address things that aren't in there now because we didn't have these issues 10 or 15, 20 years ago. So I think maybe where this originated was in a different spot than where we're ending. And so I just want to make sure that that's seen, that this isn't about, no, you can't say what you want on your personal account. I agree, you can. There's nothing we can do about it, and we shouldn't try to legally. But I don't think this puts us in a bad spot legally to say, in a non-binding document, that we think that you should not violate open meeting rules of 91A. Like, those are things that we should be able to say and expect without it being an infringement on anybody's rights, because I agree we can't do that.
Counselor Stone.
91A already covers that, so it's already a law, so that makes that a moot point. But in addition, one of the things that we need to touch on is that, again, the code of conduct is for official capacity in meetings, and that's what a lot of people keep having this hiccup with, is they don't understand. You can't draw in everything and encompassing into the code of conduct. The code of conduct is already established. That's number one. Number two is there is no ability to enforce anything beyond that.
So what's the problem?
The problem is we're getting legal fees that we're paying for to tell us that when we already know that. We already got legal opinions from January that tell us that. And here we are, and almost coming into June.
Actually, that's not quite accurate, but I would have to pull the January 10th. So what has happened since January 10th is there was guidance from the council to investigate the possibility.
That I'm aware of.
So let's stay on that line of topic. And what Councilor Keir is saying is that we, being the policy committee, have done due diligence with the guidance, that the direction that the council has given us. We hit a brick wall as far as NHMA is concerned. Then we went to legal counsel. We investigated that. She is correct in that these are suggested guidelines that could be included into the code of conduct that have nothing to do with trying to limit somebody's freedom of speech. It has everything to do with good best practice in how to conduct yourself on social media in an official capacity. And I think we are short-sighted if we think that this is evident to everybody who may be elected to these seats, because it's not necessarily self-evident.
Clearly.
And the code of conduct was drafted in 2003, before social media took off, and listing these, this doesn't even require any more legal counsel work. All you have to do is take what she's put in her email and fold it into the code of conduct. But I think it's important when you have people who've never been elected to a position to have some type of documentation that gives you some kind of guidance. Otherwise, you're reinventing the wheel all over again. And I can tell you, 3 years down the road, something's going to come up with regard to social media, and all of these concerns will be percolating, and reactions will be made, and there's nothing in writing anyway. And we may be repeating this. So it's in everybody's best interest to capture the work that's been done, in my opinion, include it into the code of conduct about guidance on how to operate on social media in official capacity, and leave it at that. Counselor, who had their hands up first? Counselor Pope.
I think we're going down a path of reholding the censure hearing, to be honest, but I do want to ask Councilor O'Hearn at the State House. I have seen censure hearings of various representatives over the last year or two for things they've posted or said. What is their code of conduct for that leads to these censure hearings?
Well, I don't know if it's a code of conduct. It's basically if you do something in the function of being a representative. If you say something on the House floor and the body feels that it was inappropriate, they can ask, censor. I don't know if they use the word censor, but for an apology at the well, which basically comes down and having that representative apologize. We just had training about harassment and diversity, and one of the things was again talking about you can't. There was somebody asking about what you can say, but you can't. Again, I'm going to have to agree with Councilor Stone. You can't bind the governing body or the elected officials has the right to freedom of speech. And when and again, code of ethics, is that the one that applies to boards and city employees?
Code of conduct.
Code of conduct.
Yeah.
That's the problem, because boards are appointed by the council. They're not elected officials. So we are the governing body, and we have the authority over those boards and committees. As an elected official, again, the people have the right to decide whether or not you're going to come back. If somebody does something here, says something that's inappropriate, the body may say, okay, you need to rectify that and apologize for that inappropriate comment. But again, we can never bind the next governing body that comes here. We can't make something that's going to bind somebody else that gets elected. I think this is kind of going down that road, so to speak. And I would suggest, as far as instead of the code of conduct, is that we have training, because I've had training over and over through my years. Again, give an example. I have an email that's personal. I deal only with personal things through my email, that personal email. I also have an email for political, for when I run for campaigns, which is strictly for campaigns. I also have email for the legislative, which I deal with in things with legislative, and also when I'm dealing with something as a council, I send it through that email. I would hope that people would also do that, knowing that I am a legislator. If you were asking me for something as a legislator, send it to the legislative email, not to the council email, because I'm in one frame of mind when I'm dealing with the legislative as compared to the council. So, but that was through training. It wasn't through a code of conduct.
Follow up on that? Yeah. I would agree about the training for harassment, because I think that came down to a little bit more of the issue in the past. And I'm going to end that there. When it comes down to code of conducts, I am very familiar with having a code of conduct upon my profession that does, believe it or not, go right into this, because the teacher's code of conduct, which was passed by the House and Senate and signed by the governor last year, does in fact limit what I can say, both as a teacher, both up here and both on my personal Facebook page. Believe it or not, you can look at that, and can be reported in any way by a parent and such, and I can lose my job and my certification. You can look that one up, and we've already had some incidents of that. So I do have to be very careful with the way I say these things and the way I post on social media, be it private, public, things like that, because I can lose my job. I also know that there are several employers that do hold social media policies for their employees that if they're posting certain things on their Facebook page, they can be fired. That's part of the employee at will also rule in New Hampshire. But I just want to say that there are some codes of conduct that some counselors do have. But I think going back to your statements, I think we do need to have the harassment training, and that should be right at the beginning, the harassment and conduct training. That should be at the beginning of terms and not when things kind of go a little bit awry. So that's something I would really suggest for future councils, that is within January, the second meeting. And then after that, if you break that harassment training, let the hounds go after you. Okay? I mean,
All right.
Baskerville, isn't it?
Yeah, that's what I was thinking. Counselor Keir?
I don't want to beat around the bush because it seems like for me, I feel like I'm talking about two different things here. I know I am the one who motioned for a censure of Counselor Stone. And I know that's where this originated from, but for me, that's over and done with.
Right.
That's not a thing anymore, and I am personally over it. I have no hard feelings towards Counselor Stone. I may not have agreed with what he said, but he has the right to say it, and that's true. And I don't at all try to contest that. What I think is that this has evolved since then to be what do we need to have as guidance in our code of conduct. I absolutely agree. I think a harassment training would be fabulous. I think that's a great idea. But I think it doesn't, for me, I keep thinking, like, what is the harm in putting this in our code of conduct to add guidance on these matters? It's only in official capacities. It has nothing to do with your private life. So for me, I'm having a hard time with it, and I think people are too closely relating it to the two things, and for me, it's not about those two things. It's about that was something separate, this is what we're looking at now, and I don't see it as being anything against anyone personally or against your personal accounts. It's about official business on official accounts or in an official capacity. And I think, as we kind of said, that's already an understanding, but we should put it in writing so that it's known as the understanding and the expectation.
So,
That's my
Counselor Hearn.
Hypothetical question, Councilor Kier. If somebody was to violate that code of conduct ethic or code of conduct, what would be the ramifications?
There's no ramifications. It's guidance.
I would-
The ramifications would be if you're elected again next year or in the next 2 years. That's not for me to say what the ramification is. It's a guidance to say when you're on official business or you're on an official account, this is how we expect you to work and to whatever I'm looking for, how to conduct yourself.
So anyway, let me kind of stop this conversation at this point
yeah,
because
it's becoming an agenda
it's
item.
becoming, yes,
Sorry.
and it was supposed to be a committee report. But what I think I'm hearing from the council is there's no desire to pursue this any further as far as legal counsel. So, is that correct? That's correct. Counselor Stone.
Should I make a motion not to expend any more funds for legal opinions in regards to this matter?
I don't think you need to make
we
a
don't need to make a
motion.
motion?
We just were looking for, we being the policy committee, we're looking for guidance. I think we understand what that guidance is. And then, based on what has been said tonight, let me do some research to find out if this harassment training even exists, to see what can be done in the future. And then let me draft something with regard to the code of conduct, and you guys can look at it as an agenda item. If you like it, you like it. If you don't, you don't. How about that?
Good.
Councilor Kowalski.
I have the code of conduct in front of me, and
Oh, good, 'cause
it addresses board members, and if we're going to have, I may change my stance on this, if we're going to have legal counsel look at something, but, so, it says in here that to this end, board members should avoid acting on matters in which they're biased, have preconceived points of view, have direct interest in the outcome, or under circumstances where they have prejudged the issue at hand. So the part that I question is, This is not to say that board members acting in such capacity cannot have predisposed views about public safety, economic development, and other interest concerns. It's kind of a weird statement. So if you're a planning board member, you can talk about how you don't want this project before even hearing the merits of it in any capacity.
Well, we're kind of off topic, so let me just
It's not
say-
really off topic, though. If you're going to expend money, I'd like that fixed.
No,
No, we aren't going to
we're,
expend.
we're
money.
not. That's
No.
the,
But I may be in favor.
well, for this point in time, the guidance was
Not to.
with regard to social media. Now, what you're saying is maybe you'll change your mind, but
But you're talking about going, you just said you're going to add in language and look at the code of conduct and then come back to us with something for our review if we want.
committee, this was a committee report section of the agenda. All I'm trying to do is get guidance for the policy committee meeting tomorrow. We have another agenda item that we have to deal with, and we have people who need to go home tonight.
I
And
understand that.
not us, I'm not talking about us, but staff who have been here all day.
But didn't you just say you were going to draft something and put it before us?
No, I said, let me find out based on the conversation, if there's harassment training even available and how that would look like for the next council term. And two, let me do some thinking on this and see if, given the concerns that have been raised, and draft something for your consideration at a later time, because now is not the time to deal with that.
And that was
This
the
is-
part
this is
where
a-
I was just suggesting if you were drafting something, you'll look at that.
Okay. And there, I'm sure there's lots of things that need to be looked at. It was written in 2003. Counselor Pope.
I'll try to put this on an end. First off, I will say Primex does provide some exceptional harassment training. I have to take it every year, and that's part of my job. That's part of state law that I have to take that. Primex just happens to be our provider that makes us have to take that. The next thing is I would suggest, and I know I'm jumping ahead to future agenda items and directives, that at some point we look when we have some time, probably not in the next few weeks, but to put something like the code of conduct on there, and that we have a little bit of a broader discussion at the council level and some understanding of what it involves with us.
Right?
I mean, otherwise, we're just going to be sitting there spinning our wheels and guessing
Yep.
this tonight.